Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC, immigration.com. Today is January 5th, 2023. As usual, when you logged into the community conference call, you would have heard our standard disclaimers. Those disclaimers apply. With that said, I'm going to go ahead and start first with the questions I have designated as frequently asked questions. I will then ask you if you have any follow-up questions based upon what I have discussed. In the end, if time remains, we will open the floor for new questions. Otherwise, if we have only, in that hour, we can only deal with the questions that have been posted. That's how it will have to be. The first frequently asked question came from, let's see. So this was, I think, the first one, which was effect of typos, typographical errors on immigration documents. Well, generically, that's a difficult question to answer. But the way I analyze this is my first question in this series of typos would be, first of all, was the typo something you did, or your lawyer did, or your employer did, or was the typo something the government did? So if the government did something wrong, you are in a much better situation. But if you made an error, government can very well take the position they expect you to refile whatever you had filed earlier, rather than correcting it without charging you anything. So it's the first question really is, did you make the error or did they make the error? It's not that they always will hold you responsible even if you have mistakenly done something, but they are within their rights to do so. Okay, so that's the first question I ask. Second question I ask is, what is the document we are talking about? Okay, so for example, if it is an employment authorization document, that can be corrected while you continue to use it. So that's not difficult. But in this case, the question is, somebody has just finished their master's degree on F1 visa in December 2022. They went outside, but they hadn't noticed that the ERD card had incorrect date of birth. Would he have any issues entering the United States? Documents that he has is passport, EAD with incorrect date of birth, offer letter, OPT approval, I-20. Now, the first thing I would do, you can send in a request to the USCIS for correction of the typographical error. So I would take a screenshot of that request that your friend has already made and attach it to the rest of the documents. Now what has happened is you have enough to show who you are, and you have proof that you've asked for correction of the document. With that additional step, I think you'll be fine. So a typographical error depends upon who made the error and in which context it's being raised. Sometimes it's just an easy fix, sometimes it's more complicated, but let your lawyers help you with that decision. In this case, I think if you have a screenshot of a requested correction, you should be okay. If anyone has a follow-up question on this, what I have just discussed, press *5, please. *5 if you have a follow-up question. Oh, by the way, I forgot to ask if you guys can hear me okay.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you all? Yeah? Oh, okay, good. Okay, so there's no follow-up question.
The conference is now in presentation mode.
Let's go on to the next one. This is concerns about EB-1C Green Card Portability. So generically, before I get to the question, most of you know about I-485 or AC-21 portability. The idea is my I-140 is approved. My 485 has been pending 180 days. If you want more on this, just go to our frequently asked questions on immigration.com. Okay, we have discussed this many times in much detail. So the point is EB-1C jobs are also portable. So let's say IBM India sent you to IBM USA, filed for your green card, I-140 approved, 485 pending 180 days. Now, let's say Microsoft offers you a job. Can you port over to a company that's not a part of the IBM group of companies? Sure, no problem. As long as the jobs are same or similar, the companies do not have to be a part of that conglomerate. That was a requirement for EB1C. That's not a requirement for AC21 portability. Okay. So that is how EB1C portability works. Now, the question here is a little bit different. Let's say my I-140 is approved under EB1C. Can I transfer that to EB2 national interest waiver from another employer? Sure. EB1, EB2, EB3 priority dates can be interchanged. So if you have an EB3 approval, I-140 approval, and you file an EB2 based green card, which is the experience of many people here already, or you file an EB1, you can always port the EB3 priority date to EB3, EB1. So EB1, EB2, EB3, all of them can be ported one from the other. Okay. *5, if you have a follow-up question on this, press *5. Okay. Next frequently asked question, who is required to pay for an EB1C green card? So we know that for perm-based green cards, there are strict requirements what the employer has to pay for. Here, my question would be, it depends. First of all, generally speaking, L1 EB1C, there are no requirements of any kind that say that the employer has to pay. The employee can pay for I-140, the employee can pay for I-485. There is no requirement legal. Okay. But what if somebody is here on an H1B and they are then doing an EB1C? That happens too. I think then it becomes a little bit more complicated. Why? Because under the rules of H1B, whatever is the employer's normal business expense, they should pay for it, not the employee. So then the question is an EB1C green card filing normal business expense? That's a question that's very difficult to answer in any bright line way. But I would say there you could have some argument that the employer should pay for it. But if you're on L1, there is no requirement that I can see the employer is required to pay. Okay? *5, if you have a follow-up question on this, press *5. All right. Interesting question. Can too many parking tickets affect green card or citizenship process? If someone gets around 50 parking tickets in a year, how does that affect visa, green card, citizenship? Well, I think it has no effect. Why? Because parking tickets are simply non-moving violations. You overstepped, either you parked in the wrong place or the meter ran out after you parked. That has no consequences. That doesn't worry me. However, if you get too many moving violations, if you get 50 moving violations, speeding, there are two components to moving violations. There is recklessness, which can become criminal, and that could become a major issue by itself. Or many speeding tickets that are not criminal, they could lead to a conclusion that you are not a person of good moral character. You are too careless. If you have too many of them. I had multiple moving violations when I got my naturalization. Not a problem. It can happen. But if it's way out of any proportion, 50 a year is a lot of moving violations. Parking violations, don't worry about it. Moving violations, I would be more careful. *5, if you have a follow-up question on this. Okay, let's go on to the next frequently asked question. Oh, by the way, I had to remove two questions from our consideration today. One question was just too many facts, too detailed. I think you should do a consultation. I have already sent you, when I took that message off, I sent you a message that you should arrange for a consultation. The other one was about political asylum. I don't do political asylums. I've said that many times before. So I couldn't really answer that question. The next frequently asked question is, and this is another interesting one. US citizen child living in India applying for parents' green card at the age of 21. Can they do that? The answer is yes. So let's say you guys were living here and you had a baby, and by the time the child was 4 or 5 years old, or even 10 or 15 or 20, you left the United States to go back to India. Now you've been living in India for 10 years, the child has turned 21, or in this case, the child is going to come to USA to study. She's a US citizen. She's a born US citizen. That cannot be taken away. Green card can be taken away, but citizenship cannot be taken away. So once she turns 21, she can definitely apply for you as long as she's domiciled in the United States by the time you go for your green card interview at the consulate. Okay. Now there are some issues about how does a child then or a young adult then prove that they can file the affidavit of support. That part could get a little tricky, but you can always get a co-sponsor for the affidavit of support, and you can also use your own assets, liquid assets, which can be converted to cash, to show that the affidavit of support is fully substantial. Okay, so can a 21-year-old file for parents? Absolutely, no issue about it. And it only takes about a year and a half. That's the timeline. Okay, because of the processing times, it might take a few months over, but the idea is that that green card is immediately available. Rest all is processing time. Okay. *5 if you have a follow-up question on what I just discussed. All right. We are zipping through these. I think we might be able to accommodate new questions today. I'm going to try my best. Options to upgrade to EB1C as an international manager or executive. So my priority date is July 2014 under EB2, pending I-485, got my EAD-AP. I'm a manager in my current company and I manage teams in India and USA. Can I upgrade? The answer is yes, you can upgrade, but it is required that you work outside USA for 1 year, or you must have worked outside the United States for 1 year out of the 3 from today when you apply, or from the date you enter the United States if you are working for the same group of companies. So the times are a little different, okay? But if you have never worked as a manager outside the United States for this company, you will have to go outside USA for 1 year. If I visit India and work for 3 to 4 months, can the accumulated time over 2 to 3 years be used for upgrading to EB1? I don't know what that means. If you are on the call, please press *5. If you are on the call, I have a question for you. Press *5 if you are here. Okay. So I don't know what you mean by accumulated time. So normally the 1 year should be contiguous. It cannot be broken up like 3 months here, then 9 months in USA, then 3 more months. That becomes complicated. I think I haven't looked at the regulations on this with this particular thing in mind. There might be some argument there, but I am assuming that's the law. You can have your lawyers research, but I think you should be doing 1 year pretty much, not continuously, but at least not interrupted too much. That would be my guess. And this is just a guess. I have to look at the law. Okay. If I visit India I would also like to know if I can renew EAD from India. No, you cannot. You cannot renew EAD from India, not so far. And if your advance parole expires, your 485 will be shelved. It'll be gone. Okay. So make sure you keep your advance parole and or your L1 visa, if that's your visa, active. Either one of them. Okay. *5, if there's a follow-up question on this, press *5. Okay. So there are no follow-up questions. Let me get started with the regular questions. This is question number 8. Oh no, are there anyone before? Oh yeah, there are some. Sorry, there are some before that. Let's go back up. This is question number 2. Calculating the number of days outside the United States during naturalization. I received my green card July 1st, 2018. I was in the US for 35 days. Immediately applied for a re-entry permit. Left the US for about 13 months. So that interrupted your stay. You returned on August 15th, 2019. You're completing 5 years of green card on July 1st, 2023. Well, you will have to wait to at least 4 years and 1 day, right? And I think that begins to be counted from August 15th, 2019 when you returned. So for you, the rule will be 4 years and 1 day to be accumulated, to be counted from the date you returned. And out of those 4 years and 1 day, you must have been physically present in the United States, I believe, for 2.5 years. Okay? So that rule doesn't change as far as I recall. But all of this is on USCI's website, the calculation, how to calculate the 4 years and 1 day, etc. So the way I see it, you should be able to apply. Now that's something I have to double check. I don't think you can apply 90 days ahead, but double check that also. But August 14th, 2024, you should be able to, or 2020, August 15th or 16th, 2024, you should be able to apply, if not 90 days earlier. 2.5 years. No, because once you have interrupted the residence, I don't think any time before that counts. I think you have to reaccumulate the time in that 4 year 1 days. Once I completed, what is the best way of explaining a single 9-month absence? You have to tell the truth, whatever the truth is. It's not like you can make up things, right? So if you have any follow-up question, press *5. Press *5. Okay. Let's go on to the next. Oh, there is a follow-up question. This is from India, it looks like. Or is it? Yeah, it is India. Go ahead, please. I can hear you.
Yes, Rajiv, it would be August of 2023, right? Not 2024.
Oh, yeah. Thank you.
4 years.
Thank you for correcting me. Absolutely. 4 years. 4 years and 1 day. So that's what, approximately August 16th, 2023, not 2024. My mistake.
And 2.5 years of physical presence during that 4 years, 1 day.
That is my understanding. From what I remember, I did the calculation for somebody a while back. Our team takes care of all these details. But I believe that's how it was. I don't have enough time, otherwise I would have looked it up for you. It's on USCI's website. You can go to their policy manual. It describes exactly how it works. Yeah, don't worry. It's very easy to follow. It's not difficult. Okay.
All right. Thank you very much, Rajiv.
Good luck, sir. Okay, let's go on to, oh, there is somebody else who has a question. Or did I just, I think I just answered this one. Okay, done. Let's go on to the next one. This one is question number 3. Renewal. Oh, what did I just do? I just went up. This is about renewal of F1 OPT visa. Okay. Documents required and change of status to H1B. I'm a PhD graduate working in GE as a lead engineer on OPT. OPT started in, I believe that's Feb 2022. I have 2 more years of valid OPT period. I'm planning to travel to India to renew my F1 visa through drop-in. You know, I'm always nervous about people going for visa stamping during their OPT. I have somebody would call me for a consultation a few years ago. Very difficult case. She was in her 3rd year of PhD and she had to renew her visa and she went to India for her project and they denied the visa. So I'm always nervous about, I hope that is not a common thing, at least I don't think it is, but be careful. H1B is a lot easier because, especially because you're working for General Electric, which is a good company. So I just don't like it. I don't like taking this kind of risk. If you're on the call, press *5. Okay, so I'll cover one thing. I won't talk about documents because the consulate website tells you what to bring. But I'll tell you one thing. What if you go and the F1 is rejected? Can GE, first of all, can you continue working for GE from abroad? And the answer is yes, if they allow you to. They can pay you as an independent contractor on a 1099. GE may not be willing to do it. Can they apply for your H1B while you're outside the United States? Sure. You can go through the lottery and you can go through the H1B visa stamping if you get approved. Definitely. So since you're not here, Akshay, there's not much else I can tell you. But the bottom line is, I don't like the idea of applying for a student visa during my PhD. But then again, I don't know exactly what was wrong with her background. When she consulted me, she didn't tell me anything beyond what the denial and the consular interview said. I don't think it's a risk worth taking unless you absolutely have to. Okay. Next question. Oh, anyone has any follow-up question? Press *5. Okay. Let's see what is the next question. Okay, all these are frequently asked questions. Traveling outside the United States. This is number 8. Outside the United States on conditional green card and applying for re-entry permit. I'll travel to India for 5 months on conditional green card. So I asked my lawyer to visit India. They told me if you leave for more than 3 months, we recommend re-entry permit. Look, the magic bullet is actually 6 months. So, re-entry permit $4,000. I think that's unnecessary, but I don't know your case enough to give you any further guidance. But if generically I were asked a question, I want to go outside USA, whether you have a conditional or regular green card, and I'll be gone 5 months, I wouldn't worry about it. Okay, because you got your green card in May 2022. September you got it approved, and now you are leaving. And I'm assuming you got your green card based upon marriage. And I think your case would be exceptionally strong if your wife was also going with you, or your husband. I'm not sure. It's Priyanka. So it's your husband. If your husband is also going with you, or if there's a real good reason why you're gone for a relatively long time. Normally they don't question you if you're gone for less than 6 months. Okay? Because when you are gone for 6 months or more, you are treated differently than if you're gone for less than 6 months. *5 if you have a follow-up question. *5. So my wife is on F1. This is the next question, number 9. F1, we need to apply for change of status to H4, apply her EAD. Which is the better choice? Go to Mexico, get H4, then apply for EAD, or apply for change of status? Well, what I would do is, if I were you, I would simply assess the time. The times are online. You know that how long they are taking for visas, and you know how long they are taking approximately for 539s. So whichever one is faster, I would do that and then apply for EAD. That's the simple answer. Okay. *5 if you have a follow-up question. All right. So there is a follow-up question from area code 530, which is California. Yeah, California. Go ahead, please.
Namaste, Rajiv ji.
Namaste.
Actually, I assessed this is Amit. I asked this question.
Yes.
So I checked the time on USCIS processing time website, and I was actually confused because then I checked the EAD filing time on that website.
No.
If you are filing
Amit ji, Acha, did you find the times were different?
Yes.
When 539 was filed with the EAD and when it was filed separately?
Yes, I checked the time for both, and it was saying 6 months. So I was confused whether the 6 months include the change of status application or it is separately. So that means will it take 1 year if I file change of status and EAD together?
I don't think.
Or it will be in total 6 months?
Yeah, I don't think it should take 1 year. 7-8 months was normal.
Okay.
Some of my colleagues are reporting that they are getting EADs as quickly as 3 months, but I don't know whether that is really true for everyone. There are two things you can do. I don't have an answer to your question because I haven't seen how they've displayed the times, and I won't have time right now to go over that. So as a practical matter, you can do two things. One, you can call the USCIS and ask them. Okay. Go through the customer service, ask them. And if you get a satisfactory answer, you know what the processing time is. And if you are in doubt, then I would definitely go get the visa stamping and come back.
Okay.
Okay?
Okay.
That's what I would do if I were you.
Fine.
Good luck, sir.
Okay. And Rajivji, one supplementary question. How, like, whenever we have we need a clarification on the responses from your help@immigration.com, whom we can reach out, because I actually tried to get a fees estimation for this, and I was kind of confused. So after multiple tries, I did not get a right answer.
If you have no, help@immigration.com comes directly to me. So if I sent you a confusing answer, I apologize, because I think I'm pretty clear with my answers. Because help comes directly to me. That's my email address. If you send it,
I will write again then.
Yeah. It could be See, what happens is, like most firms, we have something called catch-all address. So if you put down, for example, President Biden at immigration.com, that email goes to somebody else in the firm. That doesn't come to anybody. Or if you make a typo and it's not somebody's address, it goes to a generic email address. But you should still get a response. So we have a catch-all mailbox also. But help is my personal email. Okay.
Okay. I will write again.
No worries.
Thank you so much.
Good luck. All right. Yeah, I don't promise that I will be able to answer your questions by mail. I might ask you to set up a consultation. Some questions I can answer, yes, no, easy questions. But I can't write an essay on email. That's a little difficult. Takes too long. So then we already did these. Another 3 minutes, I will lock the conference. This one is question number 12. EB2 to EB3. Can a new I-140 be applied in EB3 using EB2 PERM? Sure, we do it all the time. Can one still refile interfile I-485 using EB3 I-140? Yes, you can. Because when you file a new I-140, you then get two I-140s which can be used. You get the EB2 I-140, you get the EB3 I-140. One does not overrule the other. What limitations would one have to change jobs? No limitations, just like any other I-140. I have an EB2 I-140 approved with 2013 priority date. I have applied for 485 in 2022. I received EAD. Currently employed with the same employer. With EB3 now ahead of EB2, I would like to be prepared. So can a new I-140 be applied in EB3? Sure. Without impacting my current 485? Absolutely. We do it all the time. If I use my EB2 485 EAD, can I still refile interfile? I really don't know why people have been asking me that question, because as far as I know, even if you use your EAD, it doesn't mean you are stopped from making an interfiling request to EB3. I don't see any reason why that should be a problem. What limitations would I have to change jobs? So, the only limitation is this. Remember how you have that I-140 approved, 485 pending for 180 days rule? So when you interfile to EB3, for example, your 180 days begin from the date of the receipt by USCIS of the interfiling request. That's the only downside. So the 180 day will be counted from the date of the interfiling. Okay. *5. If you have a follow-up question, press *5, please. Okay. Great. We have half an hour to do new questions. Plenty of time today. So let me just lock the conference so that I make sure everybody who's here who has questions get their answers. 1 second.
The conference is now locked.
All right, ladies and gentlemen, any questions, press *5 on your phone. Any questions, press *5. And I'll take you in the order that you logged in. I have 5 people with raised hands so far. And they're all pretty much logged in within 10 minutes of each other. Okay, let's go first with area code 703, which is my area code. Let's go to Virginia. Virginia, go ahead. I can hear you.
Hey, Mr. Khanna. Thank you so much for hosting these. I wanted to know how safe it is to travel to home country while doing the day one CPT course.
Ooh, that's a tough question to answer. So if you had asked me this question 2 years ago, I would be definitely more nervous than I am today. Okay. What has happened is USCIS has started accepting day one CPT under President Biden a lot easier and better than they did under Trump. So if you were my friend and I was not advising you as a lawyer, I would say travel only if you have to. Why create a problem if there is no problem right now? But if there is a life or death emergency and you need to travel, I think you are reasonably safe as long as you can show a few things. First of all, you have the proper CPT authorization. Second, you are still going to school, so carry some proof of attending classes. 3, carry proof that you are doing your CPT as authorized by your DSO. And lastly, before you travel, talk with your DSO. Those are the things that I would recommend. So don't travel if you don't have to. And if you have to, then follow these additional guidelines. Okay?
Got it. Thank you. Can I ask a follow-up question or do I need to wait?
No. Go ahead and ask your follow-up questions. I only have 5 more people after you. We have time today. So ask your question.
Okay. Thank you. So I've talked to a couple of lawyers before this, and one of them said as long as you're enrolled in 9 credits, which is what a master's require, you're all good. But the course that I'm doing, they require only 7 credits. So I'm enrolled in a 7 credits master's.
Okay, hang on.
The location of the university.
Hang on. Now, when you say 7 credits, does that include the credits you get for your CPT?
Yes.
Okay. So I don't know of any master's degree course that requires 7 credits, but of course, I don't know everything I need to know about how schools work. I would check with your DSO if I were you. Okay. Just to make sure that you're maintaining status. Specifically ask them, I am taking only 7 credits. Is that going to be a problem? Because it looks like you require, I think, 13 normally or for undergrad and 9 for grad. Okay, so double check with your DSO.
Yeah, I talked to the. Got it. I talked to them. I asked them these questions, and they just directed me to USCIS website, and they were like, everything you need to know is here. So they were not.
Give me 1
So
second.
I had to come to lawyers.
Give me 1 second.
Sure.
It's 12 credits for undergrad. So I am at a website called studyinthestates.gov, which is a website specially for students. It's maintained by the Department of Homeland Security. Okay. So go to studyinthestates.dhs.gov / what is the, I can actually send you the link. You can send me an email to help@immigration.com, okay? I'll send you the link. You can take a look at it.
Okay.
So F1 students must meet number of hours, full course of study requirements, F1 post-secondary requirements, 12 credits. They have all this details. Reduced course load. So take a look at that, and if not clear, then come back to me. We'll take a look at it again. Okay?
Thank you very much.
You're welcome. Good luck.
Appreciate it. Thank you.
You're welcome. Bye-bye. Okay. Lower the hand. Did we just do this one? Yes. So, there are some more people who have raised their hand. Okay. Now I have 6 more. Next one who had dialed in was Atlanta, Georgia. Let me unmute you. Atlanta, what is your question?
Hello, I'm an F1 student and I was expecting to graduate in December 2022. Unexpectedly, my program was extended, so I contacted my DSO. They extended the program end date. But I had also applied for post-completion OPT. So they recommended that I sent a withdrawal letter to USCIS withdrawing my OPT application. After the withdrawal letter was received at the USCIS processing center, the very next week the OPT approval came through.
Okay.
So I wanted to ask, is there any possibility that the withdrawal gets processed after the approval?
You should get on the phone with the USCIS customer service. Make sure they don't process the withdrawal. Now, I'm speaking from memory, okay? You can double check this on studyinthestates.gov. They have this information. What I remember was this. If a student is unable to finish their course and they get their OPT, they should go ahead and use the OPT while finishing their course. That's what I remember. I can't swear to it, but I remember having this issue come up, and I remember reading up on it, and that's what I had come away with. Please double check, don't take my word for it, but I think it's manageable. Okay? This is a relatively rare issue.
You are correct.
Yeah.
You are correct. My only concern was, since I sent that withdrawal request letter, if I start working and after that they withdraw the application,
No,
would that be unauthorized work?
Just contact the USCIS customer service immediately. Do it today, and just tell them that because see, if you say, first of all, you can't revoke an EAD. That's not within your power as far as I know. Okay. Once it's approved, it's yours, and the revocation letter should have no meaning. But why create a problem which could be just a paperwork issue? Contact the USCIS, open a service ticket, tell them I don't want this to be acted upon. Just want to make sure you have it on your records. My EAD is already approved. I'm going to continue working on it. I don't want you to revoke it. So I think that should fix it.
Okay. All right. Thank you.
You're welcome. Good luck. Okay, so let's go on to the next one. This is from New York. Okay, New York, go ahead. I can hear you.
Good afternoon, Rajiv. I have a question regarding filing for naturalization.
Okay.
My son, he got his green card in 2014, and he has been studying in India for the past 6-7 years. And then during COVID, and he was visiting within the 6 months limit before that time.
Right.
And in 2019, 2020, he was like close to 10 months he couldn't travel because of the flights and disruptions and stuff.
Okay.
Now he has the physical presence requirement around 950 days.
Mm-hmm.
So would he be able to file for N400 at this point?
Well,
or would that be
let's look at the law as it applies to this case. And this is my analysis without specifically reviewing all the other variations. So I can give you a preliminary opinion, but I would direct you to the USCIS policy manual, which is available online. It tells you all the details and it's fairly easy to read. Okay, so this is the way I would calculate it. First of all, I'm required to have 2.5 years, 30 months of physical presence, right? In the United States.
Okay, yeah.
Okay. So that's number one requirement. Let's leave that aside. Then I should never have been gone for 1 year or more. So he was never gone for 1 year. He was gone for 10 months maximum, right?
Yes.
Okay.
Yes.
And for otherwise, each year he kept coming back within 6 months, right?
Yes.
Okay.
Yes, sir.
So let's look at the best case and the worst case scenario. The best case scenario is that if you are able to explain, and I think you have a good explanation, he was studying. If you are able to explain
Yes, sir.
why he was not here for 10 months, which is more than 6 months, they should not consider his green card to have been interrupted, which means he has to start 4-year and 1-day clock. That's not going to be the problem. But the 4-year 1-day clock would be difficult. He didn't get a re-entry permit, right?
He got it once from 2017 to 2019.
Let's go on. Let's go on and look at the rest of the case. So let's say that the 10-month explanation is accepted. That means, when did his green card get approved? You said 6-7 years ago, right?
2014, almost.
Yeah. So
9 years.
he becomes eligible to file for a green card immediately upon completing 2.5 years of physical presence. Okay. That's the best case scenario.
Okay, sir.
Okay. Worst case scenario, they can deny the citizenship. You can apply again, no problem. So, as a practical matter, I think applying for naturalization once he has physical presence of 2.5 years in the past 5 years. Okay?
Okay.
So once he gets 2.5 years, you can apply for it, see how it plays out. It should work out. Okay?
Okay, sir. I'll contact your office.
Of course.
I would need help in.
Absolutely. You're welcome to do that. Good luck, sir. Good luck.
Okay.
All right.
Okay.
Bye-bye.
Thank you very much, sir.
You're welcome. Bye-bye. Okay. Somebody from Illinois has a question. They were logged in quite early. Let's get them first. Yeah, Illinois, go ahead, please. I can hear you.
Hello. Hi, sir. How are you?
I am well, sir. How are you?
Good, good. So, sir, I have a question on ERD and H1.
Mm-hmm.
So, I got ERD a few months back, like in last year around August.
1 second.
But I'm still
One 1 second. Is your EAD based upon 485?
Yeah.
Okay.
485.
Okay. All right.
In EB2.
Okay.
In
Got it.
EB2, yeah.
Got it.
After the downgrade, I got my EID.
Okay.
Yeah. So, but I have not used the EID. During my travel also, I have used my H1.
Okay.
So what happened was recently I had to move my company. I had to change my job.
Mm-hmm.
So I was telling my new company to file H1 transfer,
Mm-hmm.
but they were like saying me, why don't you use just EID when you have?
Right.
So my concern was like later on when anything happens in future, I have a backup, right? If I am on H1B.
Yes.
So like,
I
I'm just
I have seen many cases where, because we had advised clients to maintain an active H1B, we were saved a lot of time and trouble, because sometimes the 485 gets into issues, and if you don't have a parallel status, your EAD is questionable, everything is questionable. So I always like to have an active H1B, not an EAD. Now, the situation is reversible. Let's say you got your EAD approved while you were working for employer X. Then you joined employer Y on EAD. Employer Y or even employer Z, if you change jobs, can apply for your H1B, and to reactivate the H1B from EAD, you can just go outside USA, get an H1B visa stamp, and travel back on H1B. You are back on H1B. So the EAD use is not irreversible.
Oh, sorry, if I understood right. So even if I go on EID, you're saying I can apply H1 later on?
Yes, sir. And you can go get a visa
And then,
stamp and come back.
Come back on
Yeah,
H1.
absolutely. No problem.
Okay.
All right.
Okay.
Good luck.
And one last.
Yeah, go ahead. What was the question? Sorry.
Sorry, yeah, one last question. So, if I, like, how quickly can I start working on H1? Any idea? Like, my new company is hesitant because they want me to join as soon as possible.
So
And they were like,
I
if
would
we
say
have processed your H1, it will take
about 8-9 days, because it takes about 7 days for the LCA to come. Then the moment USCIS receives your paperwork, you can join the new company. And if you file it premium processing, the physical receipt also comes by email. So within a day or two, you receive it. So I would say 10 to 12 days maximum, typically, maybe 14 days at the most.
Okay.
Couple of weeks, yeah. Okay.
All right. Okay, got it. Thank you so much.
You're welcome. Good luck. Okay. Let's go on to, we have 4 more people in line. Next person in line is Arlington, Texas. Texas, go ahead, please. I can hear you. Texas.
Good afternoon, Rajiv. This is Himant here. I'm actually from Atlanta.
Oh, I see. Okay.
Can you hear me?
Yes, sir. I can hear you fine. Go ahead.
Yeah. My area code actually distracts. So my question is, I'm on H1B. I did not change the company, but my end client is changed to Arizona, from Atlanta to Arizona. But I'm still in Atlanta. I'll be working remotely. And my remote address, my home address in the LCA already, with the the petition which is filed during when I'm in the other client.
Okay.
So do I need to file an amendment?
Yeah. So
if it is not required, can I travel to India?
Yeah, hang on. That's rest of it is secondary. The primary question is, do I need to file an amendment where I'm working from my home and my end client changed? Correct? That's your question? Okay.
Yes.
So the way I would analyze this is, I would compare the 2 jobs. Are the job descriptions pretty much the same? That's my number 1 question. Number 2 question is, is my employer the primary vendor to both the end clients? Okay. And if they are the primary vendor, are the contracts the same? Because there are 2 aspects to this analysis. One is, has the job changed? And 2, has the employer-employee relationship changed? The job change can be looked at from the job description, duties, and the employer-employee relationship depends upon the contract between the end client and the employer. This is not a question you can answer or I can answer. It has to be reviewed based upon a review by your lawyers. When in doubt, it is always better to amend. Amendment is not that expensive. Okay?
Okay.
Good luck.
Sure. So my HR team said its amendment is not required because it's the same.
I love it
both,
when
clients
HR
or the
practice. I love it when
practice.
I love it when HR practice law. That's not their job. Your lawyer should be telling you that.
Okay.
Okay.
Okay. Sure.
Good
and
luck.
if I don't go with amendment, can I go? Can I travel to India with the new client letter?
I think it has the potential for getting you into trouble. And if you go with an amendment, all the more reason to do an amendment because you're going for consular processing of the visa. I would be if you were our client, based upon only that fact that you are going for visa stamping, I would tell the employer file an amendment. Otherwise, he could be stuck there for a year.
Right. Okay.
Okay.
Sure.
Good luck.
Sure. Yeah. Thank you, sir.
You're welcome. Okay. Second last question is again from Texas. Let's unmute. Texas, go ahead, please. Texas.
I'll
Yeah.
keep it short.
Mm-hmm.
I'm currently on H1B, but H1B wasn't pinged the first time in April 2020, but OPT was expiring in June 2020.
Mm-hmm.
So I took an admission into Day 1 CPT course, but H1B was picked in September of 2020.
Mm-hmm.
I got an approval notice in October
Mm-hmm.
2020.
Mm-hmm.
No RFE. And I wanted to carry on the studies, but I couldn't manage the workload.
Mm-hmm.
One of my team member had left, so I had a lot of work to, and I couldn't do it. So I missed a few assignments. My GPA went below 3. The university had terminated me in January 2021.
Mm-hmm.
So I'm going for an H1B stamping interview. Will there be an issue?
I'm not sure I quite understand what your issue is. I'm trying to understand it. But let me see if I get this right. First, hang on. Let me ask you a few questions. When your H1B was approved, it was approved in October, correct? Effective October?
Yes.
And was it with a change of status? Did government give you a change of status from F1 to H1?
Yes.
Okay. So you started working under the H1B?
Yes.
And you also were going to school?
Yes, I was also going to the school.
This is absolutely no problem. Why? Because only under F1 regulations you had to abide by the university's regulations about grade point average. Under H1B, what do I care? So you have nothing to worry about. Because you were not going to school on F1 visa or status. You were going to school on H1B status. World of difference. Okay?
Yes,
So no problem.
okay.
All
That's
right.
all I had.
Good luck.
Thank you, sir.
Oh, you're welcome. And the last question is from Massachusetts. Boston, go ahead, please.
Hello.
Yes,
Hi,
ma'am.
sir. So my question is, I am on STEM OPT and my visa is expiring in June. So can I travel to India before that?
Well, the answer is yes. Because technically, even if there is 1 day left on your visa, you can enter the United States as long as you meet the other requirements. You can prove that you've been maintaining status. You can prove that your OPT is continuing. You can prove that you have a job offer in the OPT and that would continue. I don't see why not. Even if you come back 1 day before the visa expiration, you should be okay. All right.
Got it. Okay.
And talk to your DSO. Make sure you're complying with all the rules. All right.
Understood.
Good luck, ma'am.
Thank you.
You're welcome. Okay, folks, good talking to all of you. This would be pretty much the end of our call today. So I'll see you again next Thursday. Everyone, take care and a very happy New Year to all of you. Bye-bye.